All right, Mr. Wong, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 18th, 2025, an officer was dispatched to a call for service in reference to a major crash. The witness stated that he observed the defendant sitting in the front driver's seat behind them and crash into another vehicle by rear-ending it at the 9,000th block of Bel Air Boulevard. The witness stated that he observed the defendant was driving recklessly prior to the vehicle crash. The officer observed a strong odor of alcohol emitting from the defendant's breath, slurred speech, glossy eyes, and slightly unsteady balance. The defendant admitted to consuming an unknown amount of alcohol. SFSTs were conducted. 6 out of 6 clues were served on the HGN, and the defendant was unable to perform the walk and turn test in one leg stand due to a past ankle injury. The defendant consented to provide a breath specimen. The results were 0.123 and 0.122.
How many prior DWIs have you in an NCIC?
Yes, he has 1 prior DWI.
Here, anywhere else, anything else? No? Great, license?
I can check.
He does have
Please.
He does have a Judge John Wong.
Right, that's who it needs to be, not Andy.
His driver's license is eligible, Your Honor.
All right, Mr. Wong, I'm going to find that there's sufficient probable cause to go forward with the case, and I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. No more PR bonds. I am now also placing another restriction on you because it's a second offense. I'm ordering you to obtain an ignition interlock, and you're not allowed to drive any vehicle that doesn't have one. If you're caught driving a vehicle that doesn't have one, you will go to jail. Do you understand? I'm sending notice to DTS in Austin so that
this courtroom session starts with a serious DWI case, but the tension quickly goes beyond one traffic stop. Ronald Umanor is facing a second offense DWI charge, while the court examines allegations involving alcohol, signs of impairment, and a disputed account of how the traffic stop began. The defense immediately questions whether the officer had enough basis to stop, pointing to the report and asking whether an actual traffic violation was clearly established. The judge pushes back, considers the information presented, and ultimately moves the case forward while imposing strict bond restrictions, from ignition interlock requirements.
every single officer in the state knows. You understand? Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with the other Mr. Wong, and he'll tell you if and when you have to come back to court. For now, I'll have you go to Victoria, sign a reset. You'll get with pre-chop for your bond conditions, and then you're free to go.
Judge, June 3rd through the 5th.
Mr. Wong, did you hear that?
Yes, I did. Your Honor, I just have one question. The vehicle that he is driving to and from work.
Is that what you were about to say? Come on up. So, what we will do,
ignition. I'm sorry, Judge. Go ahead.
is it inoperable, I guess?
It's inoperable at this time. We don't even know if it's going to be repairable. But the point I'm trying to make is that the vehicle that he drives, he shares with his mother. So I don't know if with the ignition, the system, if that's going to be something that
You're not allowed to drive any vehicle that doesn't have an interlock on it. So if you're going to drive mom's vehicle, it has to have an interlock on it, and that's it.
okay. That's just okay.
Portable.
No, I don't want you driving any vehicle that doesn't have an interlock. I mean, I want to make
Okay,
sure that if you get in the car, there's no alcohol on board. That's it. So
Okay.
if you want to get a portable device and you're telling me you're not going to drive, I'm going to have you sign an affidavit promising me you're not going to drive. So, you know, whatever vehicle you put it in, or if you're going to drive, okay, you got to have one. You make the decision.
Judge.
If you want me to give you a portable device, I'm happy to do that, but you're going to promise me you're not going to drive it.
Okay.
So I guess just let them know what you want to do. I mean, if you want to take time to think about it, you know, I'm happy to give you time as well.
Yes, Judge, that would be great. Let me confer with my client, and then we'll
Yeah,
decide.
so, you know, go
Okay.
outside, step outside, you talk, and then when you make your decision, just let us know. Okay?
Okay. Thank you, Judge.
Sure.
Judge, I'm gonna get on this side.
Yeah. Good morning, Ms. Alexander. Ma'am, you're charged with the offense of driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You are Janae Alexander?
Janiah,
Janiah? So you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On March 22nd, 2025, an officer responded to a minor traffic incident. Upon arrival, the officer met with the wheel witness officer who stated that he was conducting a safety control of a disabled 18-wheeler on the shoulder with his emergency lights activated. The officer stated that he was on the shoulder when he was struck on the driver's side by the defendant's vehicle. After the crash, the officer observed the vehicle to continue to travel southbound. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and immediately detected the strong odor of alcohol upon her breath and slurred speech. The defendant exited the vehicle, and the officer observed unsteady balance. The defendant admitted to consuming alcoholic.
This is where the courtroom takes a major turn. The judge is no longer simply discussing allegations or setting ordinary conditions. In this case, the court points to multiple pending matters, including a felony assault of a public servant, evading arrest, an aggravated sexual assault, and now an unlawful carrying of a weapon charge. The judge specifically states that the defendant has been given chance after chance to remain out on bond and fines by clear and convincing evidence, that the defendant has failed to comply with bond conditions. The court then concludes that
beverages prior to driving. The affiant officer made contact with the defendant and observed the same signs of intoxication. The defendant stated that she was on her way home from a bar and consumed 1 minute's drink at 9 p.m. The defendant stated she was unaware of when she struck the patrol vehicle. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues observed on the walk-in turn. 2 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were .202 and .201.
Any prior DWI? And
No prior, Judge.
license?
Oh, yeah.
Okay. Ms. Alexander, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Ma'am, look at me. If I find that you're using, it's not going to go well for you. I'm not asking much from you. If you do not have a valid Texas license and liability insurance in your name, car insurance, you're not allowed to drive. That is also a condition. Do you understand? How old are you, man? You're
23.
Do you have the ability to hire a lawyer? Would you like to apply for a court of appeal?
I don't have, I need one.
Okay. So Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you sign a receipt. Victoria will have you take a seat in the jury box while you fill it out. You will meet with pre-trial bond conditions, then I'll have you talk to someone here shortly. Okay?
Yes.
You're Ronald Umanor.
Yes.
You speak English?
Yes.
So you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 20th, 2025, an officer observed the defendant's vehicle in the street and observed the defendant talking to prostitutes on the street in or around the 3700 block of Tidwell Road. The officer followed the defendant's vehicle into a nearby motel and they were almost struck head-on by the defendant. A traffic stop was initiated. The officer observed the defendant to be the driver and sole occupant of the vehicle and observed the strong odor of alcohol upon his breath. The defendant refused to answer questions without a lawyer present. The officer observed the strong odor of alcohol upon his breath, slurred speech, and bright glassy eyes. SFSTs were conducted 6 out of 6 on the HGN, and the defendant refused the walk-in turn and one-leg stand. The defendant refused to provide a breath specimen.
Judge, that's not how I read the offense report. I read that after he almost struck them, they then followed him, and then he came to a complete stop in the roadway, and then they stopped him. So I don't see any traffic violation,
I'm looking at the dim side, Judge.
Okay.
And that's for me, it's a distinction from what was read. So what?
It says, they viewed the defendant, speaking to prostitutes on the street and around the 700th block of Tidwell Road.
Talking to people.
Officer stated people, sorry, Judge.
I-
Yeah, thank you. I'm just reading. Yeah. Officer stated that they followed the defendant's vehicle into a nearby motel and they were almost struck head on by the defendant's vehicle as it exited the motel parking area. The officer then stated that they have activated their emergency lights in the patrol vehicle and got behind the defendant's vehicle.
Did they let him drive a little bit and then pull him over, or was it?
Yeah, he got into my understanding is he got into the roadway and then he came to a stop and then they stopped him. So I don't see any traffic violation. I don't see any crime being committed.
I mean, I don't know. I mean, perhaps there were. She's saying that he almost hit them, right? And maybe he went out a little bit more and then sees them, and I don't know.
No, yeah, they're asking you to
Saying that
assume.
hits them, so
Yeah.
at that point they pull him over. I mean, go get the video, go
Sure.
get body cam.
Sure.
You see something different,
Sure.
always. I do think that there's sufficient probable cause to go forward with the case. Mr. Umanor, can you run his license, please?
Yes. His driver's license is eligible, Your Honor.
I am now placing a restriction on your license, Mr. Umanor. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir. No, sir, Mr. Officer.
Yes, sir.
Likewise, you are not to drive any vehicle unless it has an ignition interlock. I'm sending notice to DPS in Austin so that every single officer in this state knows if you're driving a vehicle that doesn't have a blow and go in it, they're going to arrest you and put you in jail. Do you understand?
Yes, sir.
I'm not asking much. All I want my streets to be safe, and I'm going to do everything in my power to protect it. You got a great lawyer here. Listen to Herman. He'll take care of you. Because you have a lawyer, I will waive your appearance, but you must stay in touch with him. If he tells me he can't get a hold of you because you're playing games and you've gone AWOL, I will issue a warrant for your arrest. For now, I'll have you go to Victoria, sign a reset. We'll have you get with pre-trial for your bond conditions, and after that, you're free to
I
go.
think you already had the interlock and everything previously. And it's the agency. Okay,
All
very
right.
good. Mr. Officer.
Mrs. Sierra, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer observed a vehicle engaging in a legal street race at the 12,425th block of Wood Forest Boulevard in Harris County, Texas. Both the defendant's vehicle and another vehicle passed the officer at a high rate of speed while attempting to pass each other in a competitive manner in an attempt to outdistance each other. The officer observed the defendant drive 96 miles per hour in a 40-mile-per-hour zone. A traffic stop was initiated. The defendants began to pick up speed while swerving through multiple lanes and cutting off other drivers on the roadway in an attempt to outdistance each other. The defendant admitted to speeding but denied racing. The co-defendant is a juvenile.
You run his license, see if he has a license.
Yes, Judge. Oh, he does not have a driver's license on file, Your Honor.
Mr. Sierra, I'm going to find that there's sufficient probable cause to go forward with your case. You do not have a Texas driver license. You are not allowed to drive. I'm going to have you sign with me today an affidavit, a promise that you're going to make to me that you're not going to drive. I don't care what's going on in your life. If I find that you drive, I will put you in jail. And if you're not in this country with permission and you go to jail, it's very possible immigration puts a detainer on you and you will be in there until this case is over with. How old are you, sir?
20.
Did you want to apply for a court-appointed lawyer?
Yes.
Look at me. Heed this warning. You get no more. If I find that you're a danger to my public in any way, I will put you in jail in a moment's notice. Do you understand? Think before you act. You hang with the wrong people, it's not going to go well for you. Come on. All right, Mr. Wong,
Cooch, who is in custody.
okay. I'm bringing you out now because I have great concern with your cases and the way that your bonds are set at this time. It appears that in September of last year, you pick up a felony assault of a public servant and an evading arrest. A couple months later, an aggravated sexual assault. And I'm assuming he's out on bond for all this stuff, and now he's picked up another case? You now stand charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 17, 2025, at approximately 2:46 p.m., officers were dispatched to 3099 NASA Parkway, Houston, Harris County, Texas, for an intoxicated male who had fallen off his bicycle and dropped his firearm onto the ground. Upon arrival, the officer observed other officers detaining the defendant and transferred custody to the affiant. The officer spoke to the witnesses, who stated they observed the defendant in an intoxicated state, walking along the sidewalk and stumble onto the ground, and they observed a semi-automatic firearm fall out of the front pocket of the defendant's hoodie. Witness 1 retrieved the firearm from the defendant and handed it to witness 2. Witnesses then held the defendant until police arrived. The officer attempted to question the defendant, but the defendant was unable to provide the officer with information as to why he was in possession of the firearm due to his intoxicated state. And the defendant was identified via his U.S. residency card.
Does he have an ice wall? Do you know? Mr. Cook, who's I'm going to find that there's sufficient probable cause to go forward with your case.
He does have an ice cold judge.
Did you have anything you want to?
Your Honor, I'd also like to add that a condition of his felony bond was to not possess a firearm. So it's a BPO.
I think Mr. Cook, who's they've given you chance after chance for you to remain out on bond. And I find by clear and convincing evidence that you refuse to comply with bond conditions. There are no non-financial conditions that we can do that will enable you to comply. As a result, I'm now going to revoke your bonds and I'm going to set them all at 10,004. Because of the actions now, I think that
He does have an ice cold.
you now have an immigration detainer. So, have you know anything that's going to happen with that by chance? Have you know? Okay. So I don't know if you're going to get out. If you get out, I'm ordering you to be under home confinement. You are not allowed to be released unless you have a GPS monitor on your ankle. And then I'm also on your other ankle, I will put a scram monitor so I know that you're not consuming anything. You are not to consume alcohol, illegal drugs, unprescribed controlled medication. You're not to be in possession of any weapons. Do you understand, sir?
Yes.
Okay. We need him to sign the conditions and then after that we'll set him. It looks like the felony is set for, May. Let's do 30 just in case. And then if nothing's happened in the felony, then we can do another 30 after that time. So, okay. Thanks. Good morning, Ms.
So I'm
Ellen.
here on Mr. Hunter.
Okay.
He had an issue, he bond forfeited, he's back for an arraignment today. I've spoken with the state, they've made an offer. We're asking for one setting for Mr. Hunter to consider that offer. And then the state is going to eval the case if not, and if reasonable minds still disagree.
Where is Miss? I don't even see Mr. Hunter.
He's in here. Mr. Hunter?
Has he made,
Yes, he bonded out.
sending him for a drug test right now?
Okay.
Right.
I don't know what you have offered. I like it.
And just,
I'm going to tell you now that it's not going to be this revolving door anymore.
right.
No more revolving doors for you, Mr. Hunter. You understand? If I find that you're using, it will not go well for you. You come to court whenever you want to come to court. That's not the way it works. I'm sending you now for a drug test.
I know,
I guess we'll come back Monday and address the results because it's now 11 o'clock. I don't know.
Okay.
I just don't know if it's enough time.
Okay. And Mr. Hunter just informed me he drug tested yesterday. So I don't know if we have those results yet.
The pretrial paper,
Wait, yeah.
the pretrial paper that I'm ordered for drug test, Monday and
I
Thursday.
don't know how because there was no order from us. If he's on the lam and then he makes bond, those bond conditions are valid. You know what I mean? So we can't just.
Okay.
Shh.
Okay, so when he was released, there were bond conditions in place that he needs to report on Monday and Thursday for drug testing.
Okay.
And so he did that yesterday.
You test?
Yes, Judge. We needed, from the drug test that yesterday, needed consumption, deposit for.
Okay, I'll let this.
So yeah, for the deposit for THC, window, oxy,
You will now test every Monday and Thursday. You test positive for anything else, it's not going to go well for you. You understand, Mr. Hunter? Now is the time for you, once again, to address any issues you may have. If you don't, I'm going to address it for you. Okay? So we'll let him go now,
Okay,
continue with the same bond conditions that we've always had,
okay,
and then he'll test again on Monday.
okay. And so just to let you know where this case is heading, the state has asked for one setting to eval it. And then, if reasonable minds still disagree, then we're gonna, set it for a dispositive motion to suppress with the court's permission.
I don't know. I mean, I'm just going to set up a trial.
Okay, we can do that too.
It's just way too much drama, man. I'm not going to, I'll just
Well, we'll have to see.
let a jury decide.
So you'll go do
So,
we'll stand down, Judge.
yeah, just, okay. Anna will continue like always. He's going to be back Monday on
Okay.
test.
Let's go.
Thanks. Victor Ortiz?
No, Judge.
No, this is Osman Rodriguez.
Yes.
Mr. Rodriguez, you're charged with driving while intoxicated. You're facing up to a year in jail and or $4,000. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 21st, 2025, an officer responded to a two-vehicle accident that occurred near the 5,000th block of Bingle Road. The complainant stated that she had made a right-hand turn northbound on Bingle Road and was already traveling northbound when she was struck on her driver's side by a white van. The complainant identified the defendant as the sole occupant and driver of the striking vehicle. The officer made contact with the defendant and observed red, glossy eyes, the strong odor of alcohol upon his breath, and smoke. The defendant stated he consumed 2 beers, one at work and one in his vehicle as he was driving home. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 4 clues on the one leg stand. 3 out of 8 clues on the walk and turn. The defendant consented to provide a breath specimen. The results were 0.160 and 0.177.
Did they find alcohol in the car? Substantiate that allegation.
Doesn't state in the VIN, Judge.
Does he have a license? And any prior DWIs?
He does not have a driver's license and no prior DWIs.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with the case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. That is a condition of your bond. I will have you sign with me today a promise to me that you're going to make. This is an affidavit that I take absolutely serious. I don't care what's going on in your life. I don't care if you have a bunny that needs operating. If I find that you drive, it's not going to go well for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and you will be randomly tested. If I find that you're consuming, likewise, I will revoke your bond, put you in jail. No more PR bonds for you. You have a lawyer. Because you have a lawyer, I will waive your appearance. Mr. Rodriguez, it is your responsibility to stay in touch with him. If Mr. Salinas tells me that he can't get a hold of you because you're playing games, you pick up a new case, you endanger my community, I will put you in jail. For now, I'm going to have you come up here and swear to us that you're not going to drive. I will get you to Victoria. We will have you sign a reset. And then after that, I will get you with pretrial. And then after that, you're free to go. Come on. Yeah.
Yes.
Mr.
Come on, sir.
Sir, you're charged with reckless driving. You're facing 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 21st, 2025, at approximately 10 p.m., an officer was investigating a fatal motorcycle accident with emergency lights activated, and the road was shut down from both directions. Accident investigators notified dispatch of a vehicle which disregarded all marked units and drove through the accident scene, almost striking officers and record drivers at the crash site. The officer observed the vehicle traveling at a high rate of speed and cut through an Exxon service station parking lot and turned down another road. The officer followed the vehicle and initiated a traffic stop. The vehicle accelerated and began darting in and out of lanes without using a turn signal. The vehicle then turned and came to a stop. A high-risk stop was conducted and the defendant was taken into custody. A security sweep of the vehicle was conducted and the officer observed 2 baggies of a green leafy substance in plain view on the driver's side seat, known from training and experience to be marijuana. The defendant was identified by a Texas driver's license, and the defendant was transported back to the accident scene, where the accident investigator confirmed the defendant's vehicle was the same vehicle that disregarded the marked patrol vehicles and disregarded the safety of the people on the scene. Other officers who witnessed the defendant's vehicle confirmed this. Deputy Chicoya advised that the defendant's vehicle almost struck multiple patrol vehicles and had approached officers while they had to abruptly move out of the way. And then Deputy Chicoya observed the defendant's vehicle almost strike 2 record drivers who were authorized to be on the scene. The record drivers confirmed this. Witness Cross advised he yelled at the vehicle to stop, and the defendant's vehicle began to accelerate faster. The defendant acknowledged he drove through a closed roadway.
Mr. Davis, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license? Please see the license.
His driver's license is ineligible, Your Honor.
Mr. Davis, you are not allowed to drive.
Sir.
You will be signing an affidavit with me today promising me you're not going to drive. I don't care if Jesus comes from heaven and needs to ride to church. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Sir.
I'm going to do everything in my power to protect my community. If I find that you drive, much less drive maniacally like this, as they allege, it's not going to go well for you. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, if you do, it's not going to go well for you. You have a lawyer. Because you have a lawyer, I will waive your
Defendant
appearance,
used
but
the
it
car
is your
for support.
responsibility to stay.
During an inventory search of the motor vehicle, the officer located 4 open containers, 2 empty and brown bags cold to the touch, 1 half empty and 1 freshly open. All 4 were cold to the touch and they were 4 logos. The defendant denied drinking the alcoholic beverages and admitted to being an alcoholic, having a drinking problem, but he stated that he did not have any idea how many alcoholic beverages got into the motor vehicle. SFSTs were refused. The defendant was read the DIC and declined to provide a specimen. The defendant was arrested in a blood warrant, was signed and executed.
Mr. Ortiz, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive. I don't care what's going on in your life, and you are signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, it's an offense punishable by up to 6 months in jail and a $500 fine. Do you understand?
Sure.
You will now get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you fail to blow into the device, if you consume alcohol, if you consume illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sure.
If you have a problem with drugs or alcohol, you better address it. Now is the time for you to address it, because if you don't, and it becomes a problem, I will address it for you, and I promise you're not going to like the way that I do it. Do you understand?
Sure.
I am now
No
also placing on your
We've seen
license that you're not allowed to drive any vehicle that doesn't have an ignition interlock on it. We send this notice to DPS so that everybody in the entire world, or I'm sorry, all officers in Texas know that if you're driving, you must have an interlock, and if you don't, they will put you in jail.
Yes, Your Honor.
No alcohol, drugs, random testing, and the portable device. You have the ability to hire a lawyer, Mr. Ortiz.
No, Your Honor.
I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. How much money you have at the bank, what you do for a living, what kind of car you drive, and then I'll take a look to see whether you qualify. Deputy Miranda is going to give an application. I'll have you sign a reset with Victoria. You'll get with pretrial for your bond conditions, and after that, we'll take a look to see whether you qualify. Mr. Smith, you're charged with 2 cases. You're charged with possession of marijuana. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the weed case, you're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer had conducted a traffic stop for expired registration at 567 South Mason Road in Harris County, Texas. The co-defendant was taken into custody for 5 active warrants. The driver was asked to take a bag with him containing his personal items. Inside the bag, the officer contained a small white plastic bag containing multicolored chocolate pills known to be ecstasy and Xanax. The co-defendant claimed ownership of the pills. A probable cause search was conducted and officers located a handgun with ammunition located behind the driver's seat on the floor of the vehicle, a baby bottle containing promethazine cough syrup, and a clear cylindrical container of marijuana. The total weight of the ecstasy pills was 8.4 grams. The weight of the Xanax pills was 118.2 grams. The weight of the marijuana was 0.05 ounces. The weight of the promethazine cough syrup was 5.19 ounces. The defendant, the passenger in the vehicle, claimed to be the owner of the marijuana and the gun and stated that the gun fell out of his pocket and landed behind the driver's seat.
What about promethazine and all that? Who's was there a second gun?
No, there was just one firearm, Your Honor.
Did they charge the other gentleman?
Yes.
So how can they charge him with it?
So he took ownership of the marijuana and the firearm, the defendant. Yes. The co-defendant took ownership of the ecstasy.
I thought you said that the co-defendant said the gun fell out of his pocket.
No, the defendant said that. Oh,
Got it. Okay. All right. Mr. Smith, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand?
Sorry.
I'm also ordering you, can you run his light? He's the driver, right?
no, he was the passenger, Your Honor.
Got it. All right. Oh my. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? Do you have the ability to hire a lawyer, sir?
I'm sorry.
I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. Are you working at this time?
Yes, sir.
Okay, I need to know everything about you and I'll take a look to see whether you qualify. Do not leave until you sign our bond conditions. All right. So no contact with the co-defendant and no weapons, please.
Yes, Your Honor.
By the end of this courtroom session, the pattern is unmistakable. The judge repeatedly emphasizes accountability, compliance, and public safety. We saw DWI defendants facing restrictions on driving, alcohol consumption, testing, and ignition interlock requirements. We saw a defendant warned about repeated bond problems and another case where the court revoked bonds after finding that existing conditions were not being followed. And in the final case, Mr. Smith faced possession charges involving marijuana and an unlawful weapon allegation. The court found sufficient probable cause to proceed and imposed 2 immediate bond conditions: no contact with the co-defendant and no possession of weapons. Mr. Smith was also told not to leave until bond conditions were signed. The larger takeaway is simple. Throughout this docket, the judge repeatedly made clear that bond comes with conditions, and violating those conditions can bring serious consequences. This courtroom was not about empty warnings. It was about making defendants understand exactly what the court expects moving forward. If you found this case as intense as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.